Welcome to our BDO Property Management Forum session. I'm Andrea Hunt. I'm a partner in BDO and I lead our service charge accounting business across the UK. I'm absolutely delighted today to welcome our speaker, Sarah Raymond. Sarah is a partner in the BDO Business Restructuring team, and she specialises in business reviews, contingency planning, and formal insolvency appointments. Sarah's particular sector focus is working with real estate asset-backed businesses and has significant real estate sector experience. And today, Sarah is going to discuss her views on how the relationship between a landlord and a tenant may have shifted. Before I hand over, could I just invite you all that if you have any questions, anything that you do want to raise on anything that Sarah will discuss today, to put your questions in the Q&A chat box at the end of the screen. I will monitor that, and if we have time at the end of the session, I will actually then just ask those questions of Sarah, and hopefully we'll get some feedback on that as well. Also, at the end of the session, there will be details shared of Sarah's email, where you can then contact her directly if there is anything that you do want to follow up with her. And also, copies of the slides will actually be shared with everybody after the session today. So thank you, everyone, and I'll hand over to Sarah now.
Thank you, Andrea. Firstly, apologies for everybody. I do have a sore throat, so if my voice goes or I reach for a glass of water, I will be back with you, but I just, my Marge Simpson impression is getting worse. So the theme for today, as Andrea has said, is has the relationship between the landlord and tenant shifted forever? I'm not sure that I'm going to be able to answer that question for you, but I have some insights as to where I think we're going over the course of the next year or so. So if I look to the left as well, that's because I've got the slides to the left of me. So just letting you know that. So today's session, I'm going to give you an outline or some context as to why we find ourselves in the position that we find ourselves in terms of the economic crisis. Then I'm just going to remind us of that massive government support that has been given to business and sort of give some views as to how that's being tapered off and in the impact on businesses. And then looking at what does that mean for restructuring? Just then a reminder of that we now have Crown preference back, and what does that mean for business and for secured lenders? And then there was a new insolvency regime that was introduced last year under the aptly named CIGA, which is Corporate Insolvency Governance Act, came in June last year. And there are some new measures that came into that which will impact businesses with real estate within them. And then you will have heard, I'm sure, over the last few months about the new restructuring plans, or if you haven't, you will do soon, I'm sure. And you will have all heard about CBAs. And I'm just going to touch on how restructuring plans and CBAs interact and how we might see those play out over the coming months. And then we'll take some questions. So what is the nature of this economic crisis that we're currently facing? So I'm not an economist. that's my first my first get out here. But most downturns are demand side, but this pandemic is completely opposite. It's supply dried up because of COVID and the government forcing it to dry up. So effectively businesses closed, but people still wanted to consume, and there was still demand and there was still liquidity. So when we had the global financial crisis in 2008, that was a demand side. The demand completely stopped. People didn't want to buy, people didn't want to spend. This time around, we've still got the liquidity, we just couldn't spend it. There were plenty of businesses as well before the pandemic started that were profitable, and they'll be profitable and cash generative again in the future. Unfortunately, a lot of them will have a significant debt on their balance sheets that needs to be dealt with. Unsurprisingly, because this is a supply side pandemic and downturn, there's in excess of 200 billion of cash savings lying around. So there's a pent-up demand for hospitality, and there will be a return to to some level of trading. So people want to spend money. Again, we just come back to how do the businesses restructure. And if we look at what happened in terms of restructurings last year or insolvencies, in 2020, the government measures stopped around about 5,000 companies becoming insolvent. So that's about 27% down on the previous year. So that's quite a significant reduction, and that is following through into this year. So there are a lot of companies that we view as potentially zombie companies out there that are just surviving because of the government measures. As I've said before, there's a level of debt that businesses have built up on their balance sheets to just get through the COVID period. So there are consequences out there, and how that plays out over time, we don't know yet. Nobody knows. We're incredibly quiet in the restructuring world at the moment, which is we couldn't have foreseen that a year ago. What we do know, that there's been a truly enormous government distortion of our economy because of the level of support that the government has put into business. We can then see what support the government has provided, both in terms of financial and then legislation. So as we know, and you'll all be aware of this because of the extensions to the position on forfeiture and CRA, the government support is set to continue for quite a while longer. The Treasury, HM government, is a significant stakeholder in UK PLC going forward. We know the furlough scheme is planned to end in September, and as of the 1st of July, it will start tapering, so businesses will start to have to pay 30% of the wage costs, with claiming 70% from the government. So there's quite a significant number of employees still on the furlough scheme, and as the impact of that furlough scheme pulling back will be felt by businesses. So it's 70% contribution in July, and then tapering to 60% in August and September. The other support, and massive support, that the government gave was in respect of the HM government-backed loans, which of course were given by lenders, but there's the guarantee from the government. Now, the companies have not had to pay capital or interest on CBILS loans. Those loans will have started around about this time last year, so they had a 12-month interest and payment holiday on CBILS. So companies are now and it's not just consumer-led sort of businesses. Any business that took a CBILS loan will have to start paying back capital and interest on those loans after the 12-month holiday. And then on the larger loans, the CL bills, which are larger loans, they had a capital holiday, so they were paying interest, but now that capital repayment has kicked in as well. So we're starting to see the tapering, the furloughs tapering, government-backed loans, they're going to start having to make contribution. We then had the VAT deferral for that first quarter, March and June. That's the government has extended support for that, and the companies now don't have to pay that back until June 2022. But that still, businesses are going to have to make provision within their forecasts to start repaying those monies. And of course, there's then all the other VAT. It's not necessarily just that one quarter that companies haven't paid, and PAYE that the companies will have to start making sure that they've made provision for. Of course, companies were required to pay all the PAYE on any furlough amounts that they claim from the government. So the government's been quite stringent on trying to collect the PAYE on furlough payments. Another support which has actually sort of gone a little bit unnoticed and under the radar is that the VAT on food supplies was reduced to 5%, and that's been extended to September 2021, and then the VAT that the company then has to charge or pay over to HMRC up until March is just increased to 12.5%. So companies haven't adjusted how much they charge us as the consumer. They are just paying less over to HMRC. So again, that's more support in this sort of food industry, in hospitality, where businesses have been supported by the government. And then, of course, we had the rates holidays for certain retail, hospitality and leisure businesses. So they've started to have to pay their rates now, but they have that rates holiday for the last year. So as you can see, the financial support that the government has put into business is absolutely significant. And as that support tapers off, businesses are going to have to look at their forecasting. And then we've had the legislation that the government brought in to support business. And I'm sure all of the people on the call will be aware that the government has recently extended the position on forfeiture to March 22. That was after a consultation that ran during May of this year. And the government has also extended the position on CRA, where rent days will remain at 554 plus certain arrears, 554 days. And what the government has now done is going to introduce new legislation to compel landlords to enter into negotiations with their tenants in respect of those ring-fenced arrears that I have on the slide there. And these arrears are the arrears which accrued during the period when tenants were unable to trade due to government restrictions. That will open up a debate in itself as to whether a tenant was able to trade or not trade, and what government restrictions applied. So again, there's going to be quite a bit of debate, we see there's going to be quite a bit of debate in relation to what ring-fenced arrears actually means. We all know that there was the code of practice that came into play last year, which said that tenants who can pay are expected to pay. This is a message that has been repeated many times by the government throughout the pandemic. And what the government is now doing is bringing in this legislation where landlords and tenants must enter into negotiations now to deal with the ring-fenced arrears. And the landlords are expected to share the financial impact with the tenants, whatever that means. So the extension to the moratorium on the forfeiture of leases is to allow time for these negotiations on the ring-fenced rent arrears to take place. And if the landlord and tenant fail to reach an agreement in respect of the ring-fenced arrears, this will lead to the parties having to enter into binding arbitration. That's essentially all that the announcement said. So it's very short on detail, and we'll have to wait for the draft legislation to come out to see exactly what is intended and how it's intended to operate, including the powers of the arbitrators and the terms on which that they can impose. This is potentially key for both landlords and tenants, because we've had throughout the pandemic tenants that have possibly had the ability to pay that haven't paid, and now they are going to be compelled to enter into negotiations. So it is a good thing in our view for the landlords. We do think that potentially the period of time is a little bit longer than we would have expected, given the fact that we've already been in this pandemic since for sort of 15-18 months, and you know, if you haven't been able to enter into a meaningful negotiation with your landlord now, why do you need yet another 6-9 months to do so? Another consequence of this is that we had anticipated to see a rise of CBAs and restructuring plans, which I'll talk about in more detail in a bit. We had expected to see more of those with the lifting of the moratorium on forfeiture restriction and winding up petition restrictions being lifted. Given now that there's this new arbitration process coming in, this may result in fewer of these CVAs and restructuring plans, because landlords may and tenants may actually come to consensual or agreements in terms of rent arrears and how the business will trade going forward. The other announcement that the government made recently was the extension on the prohibition of winding up petitions and step demands to the 30th of September. So it's interesting that they didn't take that date to March, which is possibly you as property managers a good thing, because you'll have something back in your toolbox in terms of how to collect rents. So what you could have is a situation on the 1st of October where a landlord could issue a winding up petition or a stat demand for breaches or arrears other than ring-fenced arrears. So you couldn't issue a petition for a ring-fenced arrear because that will be subject to this new legislation, but you potentially could take action against other arrears or breaches that have arisen under the lease. But a landlord still, at the moment, can bring debt proceedings against a tenant for rent and service charge arrears. But then the question is, once you've got the judgment debt, how do you enforce it? What do you go back? You can't issue a stat demand. You can't issue a winding up petition. You could go in and distrain, but it's cost, and it's whether or not the courts, which are really busy at the moment, whether or not they'll actually make the judgment in the favour of the landlord. The position in terms of this arbitration process is potentially a good thing, although, as I said, it's light on detail. We don't know how much it's going to cost, and we don't actually know the detail of the sort of terms of engagement for the arbitrators. One last thing on this slide is the wrongful trading protections for directors. Those come to an end tomorrow, the 30th of June. So throughout the pandemic, barring a sort of very short period of time where the government forgot to extend the protection, directors have been protected from any wrongful trading actions being brought against them in any subsequent insolvency in relation to trading that took place during the pandemic. That protection comes to an end. We can't actually see, if we're honest, that it was actually a meaningful protection, because it was very unlikely that a liquidator or administrator would be bringing actions against directors in this pandemic period, because it would be very difficult to sort of ascertain whether the directors had willfully traded sort of whilst insolvent. And so what does this mean for restructuring? So we've talked about all the measures that the government have put in place. And so what does it mean for the restructuring? So that, as I said earlier, right at the outset, there are a large number of businesses where the profit and loss accounts are still they're quite strong. They will be profitable businesses. They were before, they just paused for a while. But what we've got, because of the government support, is this balloon of debt on their balance sheets. And we've now got some key stakeholders. We've got the HM government through the guaranteed loan schemes on the bank loans. We've got HMRC for VAT and PAYE debt, and I'll talk about the change in their position in a moment. And then we've got landlord debt, and there's a significant build-up of landlord debt. So we've got a small number of large stakeholders, key stakeholders. What this points to is sort of four options really, in terms of how to restructure a business in the event that the business can't trade out and can't pay down its debt. And you can take a very blunt instrument, which is just close the business, wind it up, liquidate the assets, or you can take a more consensual approach. And so what we have on the slide here are the four routes. You've got the consensual deferral and compromise, which is what the government is trying to get landlords and tenants to reach that consensual agreement. And if they don't, they're going to make them go to arbitration, but it's still a consensual process outside of any formal restructuring process. Then you have two legal processes, which CVAs, which you'll all have heard about, and restructuring plans, which you will come to hear a lot more about, I can assure you. And actually, there's another process which is called a scheme of arrangement, which you'll rarely see it's usually for financial institutions. But those are legal. The restructuring plans and the CVAs are formal compromises of debt. So the consensual and the CBA and the restructuring plans, those save the companies. We then move into an AMA, which is an accelerated M&A process, which then leads on generally to a sale of the business through a pre-pack. And that will then just be a survival of the business as opposed to survival of the company. And the final really blunt instrument is a closure, which will lead to a liquidation. So you just liquidate the assets, close the business. Interestingly, over the pandemic period, it is CVLs, or company voluntary liquidations, which are, sorry, creditors voluntary liquidations, which have seen the increase. And that's because a lot of businesses simply just ceased trading and there wasn't a business to sell. And so they went into liquidation. So that, in terms of volumes of restructurings, we still don't know. And we're not sure what will happen in terms of the arbitration, as I've said. So the government had planned to use the measures that it implemented that we talked about just now to buy time. And it sort of government borrowed money to support the UK PLC. As their support measures are coming off, we're now seeing businesses going to have to stand alone. They're going to have to look at their future viability, whether that's a company or a business. And at some point, there will be a need to restructure. One of the key factors in restructuring is the fact that the Crown now has the return of the Crown preference, and we'll talk about that on the next slide. The Crown had preferential status for VAT and PAYE decades ago, and they gave that up when the government restructured the lending with banks. So banks were no longer able to appoint administrative receivers, and we had something come in called the Enterprise Act. And so the Crown gave up its preference as a sweetener to the lenders, and the lenders were able to have what's called a qualifying floating charge. On the 1st of December last year, the Crown preference was reintroduced. It was introduced through a Finance Act and sort of came in under the radar. What it means is it is actually the Crown now has secondary preferential status behind the claims of employees for VAT and PAYE. And the estimate is that there's around about 70 to 80 billion of amounts due to the Crown that would rank as preferential if all those businesses failed. The previous status of the Crown preference, it was limited in terms of time periods, but now it's not limited. So it's all VAT, it's all PAYE, and that is preferential. So what that does is it diverts away money that would otherwise have gone to the security of those floating charge holders, those lenders. So it will shift the attitude of those lenders when they're looking at companies in distress, because they no longer have the protection, or they no longer have that full sort of suite of security available to them. What it also does is it makes HMRC another key stakeholder in the negotiations of any restructuring. So in a CVA, HMRC's preferential status, or the status of preferential creditors, cannot be affected without the consent of those creditors. So it does, when you're looking to propose a CVA, it now means that you have to go and talk to HMRC, whereas before you didn't necessarily, HMRC were an unsecured creditor. In restructuring plans, because restructuring plans, we'll touch on this in a minute, are outside of the Insolvency Act, there aren't preferential creditors, but you still have to treat HMRC as though they were a preferential creditor, because in a restructuring plan, you have to show what the alternative would be for the company if the company didn't go down a restructuring plan. And 9 times out of 10, if it didn't go down a restructuring plan route, it would be going into an insolvency process. And if it was going into an insolvency process, the Crown would have a preferential status. So the Crown is in this interesting, or HMRC is in this interesting position at the moment. It's got a lot of power in terms of its preferential status. And in restructurings, that means it could collect in more tax take for HM government, and that's a good thing for the government because the government's borrowed so much money. But if it does that, that has an impact on the saving of businesses. So there's a bit of sort of tug of war, I guess, between the Treasury that wants to collect in as much tax take as it can, and sort of other areas of government that want to protect businesses. At the moment, it's sort of the Crown has been quite supportive of businesses and supportive of restructuring plans and CVAs, but at some point we can see that moving and shifting, and that fiscal rectitude will win out, and that the Crown will want to see more, or HMRC will want to see more money, more tax being collected. It's worth mentioning here HMRC's time to pay arrangements. So we understand from our tax team, tax disputes resolution team, that sort of assist clients with the negotiations with HMRC. The HMRC are agreeing 2-year arrangements, but they are requiring, so that's 2 years over which you can spread your PAY and VAT, but they are requiring companies to evidence affordability. So there is a shift, because prior to the pandemic, the HMRC was quite accommodating in terms of time to pay arrangements, but now they are looking for more demonstration of evidence of affordability. And again, that's just another sort of thing that HMRC, another tool HMRC has to collect in debts. Last year, as I mentioned, we had the introduction of a new act called CIGA, and that introduced 2 new regimes. One was a moratorium, and I doubt any of you will have heard of a moratorium because it just hasn't been used because of the government support measures, because you haven't had binding up petitions, you haven't had stat demands. So businesses haven't needed to go to the courts and seek the protection of a moratorium. So what this does, it gives a breathing space to companies, and the company just, the entry test is that the company is likely to be rescued as a going concern. So not the business, it's the company. And the directors go to somebody like me, ask me to be a monitor, and evidence to me that they believe that the company can be saved. I agree to act as monitor, they file something in court, and the moratorium starts. And what that means is no creditor can enforce for pre-moratorium debts, but the moratorium debts that fall due during the moratorium have to be paid. There's an exception for rent. So rent that fell due before the moratorium date is treated as a pre-moratorium debt without a payment holiday. But what the Act says is it's the rent that is paid has to be paid in respect of the moratorium period. So it's not the whole quarter. So if you went into, if the moratorium came into effect on, say, the 1st of October and a quarter's rent fell due in September, the moratorium period, the first moratorium period, is for 20 days only. So the company is only required to pay 20 days of rent, not the full quarter. The company can extend the moratorium, and if they extend the moratorium, they have to pay the rent. But it's just worth knowing for you guys as property managers, if a company gets this protection of a moratorium, the rent is defined as a pre-moratorium debt without a payment holiday if it became due, before the moratorium. And came due during the moratorium, it is a requirement that the company pays that debt. As I said, there have probably been 2 or 3 moratorium since they came into effect last June. So it will be interesting to see how they play out, whether they're used more as the restriction on the winding up petitions on stat demands are lifted. And another interesting point, of course, is actually, will companies use the moratorium if they have to pay the rent? Currently, if you're proposing like a CVA or a restructuring plan and you don't have this moratorium protection, the companies will run the gauntlet. You know, you won't necessarily pay the rent because you're trying to put a restructuring plan together, and you use that sort of, look, we're trying to put negotiation point with landlords, or some companies may just blank their landlords completely and not engage with them. But if you have the moratorium, companies are required to pay the rent. So could be counterproductive with businesses with large retail estates that moratoriums may not be a feature. So the other major development of CIGA was the introduction of something called a restructuring plan. And you may have heard of restructuring plans. Pizza Express had a restructuring plan last year. They did it with a CVA running alongside it, and that's what restructured the leasehold estate. So they used the restructuring plan to restructure their financial obligations. And Virgin Active have recently had a contested restructuring plan approved. There have been 7 approved restructuring plans in the past year, so not very many, but we expect to see more. The court did yesterday reject a restructuring plan because they didn't think that it offered the best outcome for the stakeholders and creditors. So that is interesting. The court didn't just rubber stamp something. So just a very high level, trying not to be too technical. Restructuring plans are outside of the Insolvency Act. They sit in the Companies Act, and the judgments that we have had have taken, the judges are insolvency judges. They are used to seeing CVAs. They have drawn, a lot of the judgments have drawn a lot of the same sort of references as they would in a CVA. And this is in particular looking at how creditors are treated and whether they're treated fairly. So it is a court-driven process. There are 2 hearings. There's one called the convening hearing and one called the sanction hearing. At the convening hearing, the judge hears evidence as to the support of the restructuring plan, and listens to why the stakeholders have been divided up into the various different classes. If the court is satisfied that those are the appropriate classes, and is satisfied that the criteria of the restructuring plan of under the Companies Act Part 26A have been met, then the judge will determine that classes meetings should be held. So then you have class meetings, and the creditors either approve or disapprove or don't approve in those various classes. So the key difference in a restructuring plan from, say, a CVA, and we'll talk about that in more detail in a moment, is a restructuring plan can be sanctioned by the court if one or more classes rejects it. So if a whole class of landlords rejects it, it can still be sanctioned by the court, which is what happened in the Virgin Active case. And this is called a cross-class cram-down. And it's something that, if you've ever heard of Chapter 11 in the US process used a lot. So it's the first time we've had it in the UK. And we expect to see it a lot more. We expect to see a lot more restructuring plans, particularly where businesses need to have a financial restructuring as well as an operational restructuring. So the court will sanction the restructuring plan even where there are dissenting classes, so long as the court is satisfied that that dissenting class is no worse off than they would be in the relevant alternative, and the company has to provide evidence as to what that relevant alternative would be. And the court will only sanction if at least one of the classes that are what we call in the money approves it. Court can also exercise its discretion to sanction a plan if the court thinks it's the right thing in the interest of creditors. So it's a really powerful new tool. As I said, there's only been 7. Expect to see more. It's just having a look here into the differences, just because I'm sure you're all familiar and have all heard about CVAs, but you won't have heard about restructuring plans probably. In a CVA, you have one meeting of creditors, and it's 75% of the unsecured creditors voting on the day, and it can't approve a CVA, subject to 50% of unconnected creditors also approving it. So that's what you need to get a CVA through. You can't compromise secured or preferential creditors in a CVA without their consent. And remember, CVAs are getting a little bit trickier now because of the HMRCs regaining their preferential status. And so the key advantage of a restructuring plan is actually you can compromise all stakeholders, including shareholders. So you can compromise secured creditors and preferential creditors, subject to that relevant alternatives. So if they're no worse off than they would have been in the relevant alternative, then the court is likely to sanction a restructuring plan. It's worth just noting as well that in CVAs in 2020, a number of them attempted to mitigate tenant risk of subsequent lockdowns or forced closure. So New Look, for example, imposed turnover rents on certain in the event of further lockdowns, and in the Pizza Express CVA, the company was given the right to further limit rent if lockdowns forced closure of that relevant unit. So it's just worth noting that actually CVAs evolved over the last year to sort of take into account the impact of the pandemic. I'm going to talk in a moment about some recent developments in case law, but just looking at this slide, you can see that using that restructuring plan, it is really powerful. So if we talk about the next slide, you'd use a CVA. When would you use them? When would you use a CVA? When would you use a restructuring plan? CVA is probably your go-to if you're satisfied, if you're happy as a company that you're going to get, that's the vote. And that you don't need a financial restructure, so you only need to operationally restructure the business by closing stores or it's over-rented. Hate to say that on this call, but in case it's over-rented, and renegotiate rents. And if you've got the secured and the preferential creditors all in agreement, then you'd use a CVA. The risk of a CVA is that after the meeting of creditors and shareholders and it gets voted through, there is a challenge period of 28 days that a stakeholder, somebody could challenge the CVA for unfair prejudice. And then you run the risk of not having that certainty, which is what happened in Regis and New Look, in that the CVAs have been approved. Actually, you've got to go through the whole court process to determine whether or not the court upholds that decision that yes, the CVA should stand. So you run that risk in a restructuring plan, because it is a court-driven process. You don't have that same issue because the court has sanctioned it. You've had your creditors meetings or classes meetings. The court has then sanctioned it, and you know it's done. You know you can go and implement your plan. The problem is restructuring plans are expensive. There's a lot. You've got a lot more meetings. You've got a lot more court interaction. So that is a sort of, when would you use a restructuring plan? When you need to financially restructure, or when you need a cross-class cram down. I'm really glad I managed to get those words out. Everybody knows CVAs and restructuring plans are quite controversial, and particularly the CVA, and there has been a lot of debate with BPF, with their red flags on CVAs, and landlords being unhappy in terms of being sort of dragged down, and the way that the voting has been calculated at meetings, which almost just sort of crams them down, and the vote gets carried by unsecured creditors trade creditors that tend to have been kept whole. So there have been two decisions recently. There are some other challenges going through the courts, but we don't have those. So the Clark's CVA is also subject to a challenge. So we've had the Regis and the New Look challenge. The Regis CVA, the landlord's challenge was not upheld, for unfairness was not upheld, although the CVA was overturned. But the court did conclude that the practice of discounting landlords' votes by 75% for voting purposes was wrong. And what used to happen, those of you that are involved in assisting clients and submitting their claims will know that you sort of submit your claim for the unexpired lease of the lease term. It then gets discounted back to present day, and that would then form the claim of the landlord in the CVA or against the company. Well, of course, you have to mitigate for reletting and things like that, but that's the sort of simplistic view. What became practice within the insolvency and restructuring profession was then, for voting purposes, because there is no rule within the insolvency rules to say how you deal with voting purposes for a contingent future rent, that on a contingent sort of future debt, the only rule is that the chairman can value that debt, or they place a pound value to that debt. So everybody recognised, well, actually landlords do have a proper claim. It's not just a pound. We're not going to just put a pound. But it became standard market practice to say, but we'll discount it by 25%. There was no reason, no real rationale as to why it arrived at 25%. It just became a standard practice. The court has now said that's wrong. And actually what happened in New Look was they discounted it by 25%, and that seems to have been accepted by the judge. It was the same judge, by the way, Zaccaroli. He did both Regis and New Look. He said the 25% discount was fair. That will have implications for CVAs going forward, because when you work out whether or not you're going to get your 75% and then your 50% vote to take a CVA through, you might say there might have been some gerrymandering in terms of where did you put which landlord went into which bucket. So it'll be interesting to see how that evolves going forward. Next point, just on New Look, again, the landlord's challenges were all rejected, but we do understand there is an appeal. And what we learned from that case is that there is no general principle that a CVA cannot reduce rent below the market rent. So it'd always been that sort of when you were doing a CVA comparator, you'd say, well, it's over rented, the market rent is this. Well, actually, in the New Look, the judge accepted that there is no general principle that rent can't go below that market rent or can't be converted to turnover. And the give for the landlords from the company for this reduction was actually the landlords were granted the right to terminate their leases. And that was key. It was key that they were granted the right to terminate the leases, and also that they were offered what they would have been offered in the alternative. So again, the alternative, the relevant alternative, which we talk about in the restructuring plans, is really relevant also in a CVA. So it's quite clear from those two judgments that the judge was quite sort of in favour of the company and survival of the company and the business, and sort of viewed that, you know, so long as the landlord was no worse off than they would have been in the relevant alternative, and they have the right to terminate and take their leases back, then he would find in favour of the company. So then we moved to the Virgin Active decision, which came very quickly after the Regis and New Look. I think they sort of all came in within like a week of one another. This was challenged by certain landlord creditors. It was the first fully opposed restructuring plan. There was a 5-day sanction hearing, which is why it makes it so much more expensive than a CVA. The landlords had been split into 5 classes. Some weren't impaired, some were marginally impaired, others were switched to turnover rents, and some went to 0 rent. The give on behalf of the company was that they were given 120% of what they would have expected to have received in an administration, and they had the right to break the leases. So in the judgment, this was Snowden in this instance, his ruling was that in an RP, it is essentially the in-the-money creditors that determine how value is divided up going forward. And if a landlord is out of the money and is dissenting, but they're being given, offered what they would have got in the alternative, then actually the judge was satisfied that he could sanction the restructuring plan. It was also interesting in this case, sorry, interesting for me, that in determining the alternative, you don't have to market the assets, because actually marketing could be seen to be a bit false, because everybody knows that the company is looking to do a restructuring plan, because that documentation will all be out there with the landlords. So any party looking at acquiring will think, well, is this really a true process? So that's quite interesting. And as I said, I think what we've definitely taken away, and that our industry has definitely taken away from these judgments, is just how debtor friendly the company is. So just to wrap up, Andrew, just to wrap up, we won't do the last slide, but just to wrap up, I'm not sure that I have answered the question as to whether there is this sort of the landlord and tenant relationship has shifted. I think landlords and tenants are going to have to work more closely together going in the future, and there's definitely going to be some rocky times ahead, and I think we're just going to have to see how this plays out. That's it. Questions, anybody?
That's fantastic, Sarah. Thank you very, very much. A great overview and insight to, I think, the current changes in force. I think we have come to the end of our allotted time, so I'm just going to ask anyone on the call if they do have any questions, if they perhaps could submit them directly to you, Sarah. You'll see on the screen that your email address there, sarah.raymond@bdo.co.uk. If anybody does want to just follow up some of these discussions individually with Sarah, then they will be very, very welcome. And copies of these slides will be given to everyone that's attended the call and everybody that has registered as well. And do please share with your colleagues, because I think, Sarah, you've shared some fantastic insight here. I have got lots of thoughts now from this, which we can share separately as well, and I'm sure many others will do as well. So we will continue with the discussions beyond today, I'm sure. But for now, a really massive thank you for you for taking the time to present today, especially with a very sore throat. You did a fantastic job. You've still got the throat. And thank you to everybody for attending today. We look forward to seeing you all at the next Property Forum session. Thank you very much, everyone.
Thank you.
Bye.